regularly scheduled time set for the monthly regular meeting of the Taxicab Authority Board of the State of Nevada. I will call us to order, and the record should reflect that present are Administrator Park and our Administrative Attorney, Ms. Webb, our Deputy Attorney General, and present are Vice Chairman Soderberg, Member Graff, myself, Dan Reese, Chair, and participating remotely is Member Weekly. Member Decker is excused because he has other business on behalf of the people of the state of Nevada, which is in conflict with this meeting. So we have given him an excused absence. I'd like to ask you to all join me and stand with the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Having inspected notice of this meeting and affidavits and confirmations of posting, it appears to me that this meeting has been noticed and posted in accordance with the open meeting law. Am I correct, Madam Clerk?
Yes.
That will take us to agenda item 2. Agenda item 2 is public comment pursuant to the Nevada open meeting law. This is a time set forth on our agenda for members of the public who wish to address the board and on matters which are within our jurisdiction. We may not take, as a matter of law, any action on those matters today, but we certainly welcome any member of the public who would wish to address us at this time. Is there any member of the public present in the room in Las Vegas, Nevada, who would like to address us at this time? Seeing no rush to the witness chair, Madam Secretary, is there anybody participating remotely who would wish to address us in public comment? Seeing none, I will close agenda item 2, which is public comment, which takes us to agenda item 3, which is review of our minutes of December 18, 2024. These have been made available to the members of the board, and I ask if there are any changes, additions, or corrections.
I have none.
Hearing none, I'll take a motion.
I'd move that we approve the minutes as proposed.
Second.
All those in favor signify by saying aye.
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 Administrator Park has reminded me that I forgot to do something in public comment. We will reverse engines. And Member Park, you have a presentation. Thank you for reminding me.
One of the funnest parts about being an administrator is to be able to hire people, do promotions, and also to recognize employees when their service has been outstanding. Rick has been with the Taxicab for over 20 years, and I've got a certificate for him for his service for 21 years at the Taxicab Authority. It's kind of been a long time coming. We didn't jump right on this the way we should have, but I just wanted to recognize Rick and let him know how much we appreciate you and the work that you do. So, exactly. Thank you.
Todd, thank you.
Thank you, Rick.
That'll take us to agenda item 4. At our last meeting in December, Member Weekly suggested that we invite Mr. Garvey of Pat G Group Parking to provide some input and information to us regarding the current status of taxi stands at the Sphere, T-Mobile Arena, and Allegiant Stadium. Mr. Garvey, if you'd like to come forward and edify us, we would appreciate it. been a discussion item.
Right here?
Yeah. Have a seat.
Thank you.
And then if you just put your name and your entities on the entity name on the record for us.
My name is Patrick Garvey with Parking and Transportation Group, Las Vegas. We currently are the traffic control providers for T-Mobile Arena, Allegiant Stadium. We're no longer at the Sphere, but I can speak on behalf of them for a little bit. And those are the three properties that we're going to kind of be discussing today. First, talking at the Sphere, they have a new parking and traffic provider there. It is SP Plus Momentous Technology as of February 12th. However, when we were there, the challenges that we did receive with some of the taxis were the fact that we would get probably 500 cabs on ingress coming to drop everybody off. And then on egress, we would get about 50 for pickup. And it was really quite a challenge. I know the Sphere did create taxi lanes, did create a starter position over there. We would have a lot of people waiting for taxis that would turn into rideshare opportunities at that point. Because they were sick of waiting for taxis or didn't want to walk all the way to the Venetian. Milan is still the representative over at the Sphere. I know Administrator Park knows Milan very well and can reach out, but they were calling Cabot. They were calling everybody they could to get a taxi over there. So there was quite a challenge there, even with a lane created. As far as T-Mobile Arena goes, we aren't looking at too many changes there also. The taxi pickup area is New York, and Park MGM, their regular taxi stands. We don't see too many problems there. We do get quite a bit of taxi cabs that are coming to the hotels because generally that's where the taxis like to go. They know the area, they know the positions, they know the lineup there, and it seems to work relatively well over at T-Mobile Arena. Allegiant Stadium is what I really want to discuss today, and that's one of the big challenges for both Allegiant Stadium as well as the taxi cabs themselves. We are aware there are a lot of shortcomings in our plan for T-Mobile Arena and allowing the taxi cabs to get there. Our taxi cab pickup and drop off area is on the corner of Procyon and Diablo. We turn Procyon and Diablo into a one-way counterclockwise. The signage that we have at Allegiant Stadium is lacking, to say the least. We have one sign that says taxi straight ahead, and that is when you're halfway to the taxi stand itself. I am working with the Raiders and the stadium to get some more signage out there for taxis, as well as on the egress PA system that we do. Let people know where they can go pick up a taxi. Secondarily, the path of travel for a taxi driver to get into that area is awful. And that is due to the fact that we have over-congested that area with limousines that aren't allowed to go into our VIP area. We have our employee shuttles that pick up over there as well. And we do see a lot of congestion for any taxi cab that may be driving down Valley View, wants to turn, knows the correct direction to go to. They have to wait in line for the buses to clear and everything else to clear. At that point, it makes sense for a taxi cab to go just pick up another fare at an easier place. So during this off season, we're actively working on what we can do to make it better. One thing that we have looked at doing is actually turning the one-ways to go to a clockwise one-way. So instead of turning down Diablo, taxi cabs would turn down Hacienda, take a right on Procyon, and we have a much longer queuing area for the taxi cabs. To get this to be able to work, we're going to have to do some traffic studies in this off season, make sure it makes sense for everybody that's coming in there. The walk from somebody at the stadium to the taxi line at Procyon and Diablo is about a quarter of a mile, which is very, very reasonable. We go right out the west side of the stadium, directly across Polaris through W Lot, and it drops the person right there to be able to pick up a taxi cab. If I can get a line of taxis 15 deep, we'll probably be okay to be able to make sure that we pick up the amount of guests that are there. There's many times that I've gone out. Our shift has been done. I've closed down our game day operations command, and I will see a group of 20, 30 people waiting in the correct area for taxis and not a taxi to be found. And that's after traffic is cleared. And at that point, we're trying to call Cabot, we're trying to call everything we can to get somebody over there. And at that point, the limousines that are out there just soliciting rides illegally are the ones that are picking up those guests over there. So we are actively working on it, and I am working with Mr. Park to make sure that we can make this a much better experience for both the guests and the taxi drivers themselves. So everybody is aware of where the pickup is going to be and the best path to travel for a taxi cab to come pick up a guest.
Thank you very much. Member Weekly, do you have any questions of Mr. Garvey?
I do. First of all, Mr. Chairman and members of the committee, thank you so very much for indulging me. I am in Carson City at the Nevada State Legislature, so I couldn't be there in person
Member
today.
Weekly, I'm sorry to interrupt you, but we can really not hear you. If you can get closer or turn up the volume.
Okay, is that
We're
better?
trying to on our side.
How's that? Is that better?
Yes,
Is that better?
much better. Yeah, we can hear you now.
Okay, thank you. Okay, Mr. Chairman, thank you so very much for this opportunity this morning. I apologize not being in person with you. In the committee, I am in Carson City at the Nevada State Legislature. I wanted to thank Mr. Garvey for taking the time out of his schedule for coming by to meet with us to talk to not only the Taxicab Authority, but to the industry as well. I think at the end of the day, it sounds like we've been experiencing some severe communication problems. And so, Mr. Garvey, it's my hope, just based on what you just shared with this committee, that we can continue to work with Mr. Park, but also include the industry so that everybody is aware of what goes on and what your expectations are. As you speak about your game day operations, I think what happens is, and I was at the last Raiders game as well, and it's weird now that I'm on this committee, I just start looking and just trying to observe how all of this works. You say a quarter of a mile to walk to a taxi is not that bad. Let me see you walk a quarter of a mile to a taxi after you've enjoyed a game. You may have had a nice glass of wine or a beer or something of that nature, and you're trying to find a cab. I think at the end of the day, it's just about communication and us making it all work, opposed to, the industry just trying to figure out what goes on. And then I guess my next question to you, Mr. Garvey, would be, when you say you're working with Allegiant Stadium, would that be, are you working with Piper Overstreet White and her committee, that's government affairs, or Michael Chrome's office, or is Andy from ASM Global involved in these communications as well, being that they pretty much run the day-to-day operations over at Allegiant Stadium?
I'm working with Chris Soteropoulos from the Raiders himself. He's the one that we can really make these plans through. And once we get approvals from the Raiders and Chris and his team, and he'll go to Piper, he'll go to everybody that he needs to go to. Then we will work with ASM and Andy for the operations themselves. Those are the people that we're going through to make these changes.
Okay. Okay. Well, Chris, I'm sorry calling you Chris. Mr. Garvey, do you think that moving forward, we could maybe have another meeting? I know your schedule is extremely busy, and I appreciate again your time, sir. But do you think that between you and Mr. Park, that you guys can have some type of communication with the industry to maybe ask questions as you're going through trying to revamp and look at, how you're going to make some necessary changes so that it'll work for everybody? Um, I think what you mentioning about the signage, while I was out there at the last game, I did look for sign. I didn't see signage anywhere where I was. And so you're absolutely right. The signage is not very good. And so for someone coming from out of state, who is not jumping in an Uber or a limousine and looking for a cab, if we can maybe talk about how do we make sure that we're all on the same page, so that maybe even also too the industry can do a better job with letting people know about signage, and what are some proposed changes we have as it relates to all of us working to get our riders to these various venues. Just a suggestion.
Yeah, and what I'd like to do is, after working with Chris and Mr. Park, I'd like to come back to a meeting in the future with a presentation showing exactly what we're going to be doing to improve the operations at the stadium, to be able to show where the signs are going to be, what the egress loop is going to be saying, and how it's going to be operating. So everybody here can be aware of it. And then we can work on communication and spreading it out to the industry itself.
I'd appreciate that very much. And through you, Mr. Chair, I'd like maybe in the future, I don't know if you're doing it today, but maybe in the future, just allow the industry an opportunity to ask questions so that they could truly understand what's being proposed and everybody's on the same page. But with that, Mr. Chairman, thank you so very much for indulging me this morning. Thank you, sir.
Any questions? Nope. Vice Chair?
Thank you, Mr. Chairman. Earlier, you talked about Allegiant Stadium. And I don't go there much. So when you'd mentioned that there's taxi stands at the two hotels that are on that campus, like, duh. But it never occurred to me when I was at Allegiant Stadium. And maybe this is a question for Mr. Park, maybe it's a question for you. Do people who are attending events at Allegiant Stadium know this? Because it's not much of a walk.
So I think we're confusing Allegiant Stadium and T-Mobile Arena. Allegiant Stadium.
Yes,
yeah.
that's how little I go to either. So, the smaller one.
Right. So T-Mobile Arena with the Golden Knights and the concerts that they do there, it's pretty intuitive that the hotels are right next door to where it is. That's why there was no taxi stand created. There's no rideshare area created as well. They go to the hotels too. So, I will talk with the people over at T-Mobile Arena and find out, what they actually do on, if they have an exit loop and what their signage is. I'll dive into that a little bit more to see what we can do to make sure the taxis go to the hotels. And the hotels love it because they're getting more foot traffic going in there, people waiting for a taxi, go in, decide to get some dinner, go play a little bit too. So between Park MGM and New York, it does service the needs for T-Mobile Arena when we get 18,000 people there versus 60,000 at Allegiant Stadium.
And then when you talked about Allegiant Stadium, the Raiders Stadium, as I call it, you said there's a certain entrance exit in that stadium that leads you to the taxi stand. And it's about a quarter-mile walk. And I see what Commissioner Weekly is saying, that quarter mile right now, be okay. But the Raider season starts in the summer and it stays hot here till October. And then it gets into the winter when it's actually, sometimes we could have very inclement weather. I'm trying to visualize, is it that obvious? I come out that door, even though it's a quarter mile, I can see a bunch of cabs, or is it convoluted?
It is absolutely not obvious. And that's what we.
So there's things in between.
Well, it's not so much things in between. It's just people won't know where to go. They'll walk out of that side of the stadium. And if they don't know already where the taxi drop off pickup area is, they're not going to find it as it stands right now. And that's what I need to work on with the stadium, with Mr. Park and Mr. Weekly, or Dr. Weekly, sorry, to make sure that it becomes intuitive for the guest that's leaving the stadium on any side of the building where to go to pick up their taxi. The quarter mile walk that we're talking about is the same amount of walk that an employee does to get to the employee shuttles. And it is half the walk that it would be if somebody were to go over the Hacienda Bridge to Mandalay Bay to try to pick up their cab, which is a 10 or 12 minute walk in that heat. That we're talking for this one, a 2.5 minute walk to get to the taxi cabs. It's very, very, very close. It's equidistant. So the taxi cabs pick up about a quarter mile to the west. Rideshare picks up about a quarter mile to the north. I mean, it's absolutely equidistant there. And it's a much easier walk to get to the taxi cabs than it is over to Lot N, where we do our rideshare, where you have to cross either over Hacienda or under Hacienda, and it's kind of messy over there.
Sure.
The taxi cab is a very clean walk.
Okay, so the issue there is awareness.
Yes.
That's what you're saying.
Yes, I think that's
Event's
issue number
over.
one.
You've had maybe a few adult beverages, maybe not, but you didn't really look at which one you came in, even though cab brought you up. Now you got to go, oh, damn, where do I find a cab? And even if you come out of the right exit, it's not like they're right there.
Right.
So, okay,
It's-
so it's an awareness thing. And secondarily, cab dispatchers need to get more people there. You see, typically, at least with the Raider game, you see people standing around and no cabs at some point.
Correct.
So there's rides to be had. They're not being had because just at some point, I'm sure some people, they'll go there for a certain time afterwards and then they'll go to some other cab stand. I understand that.
And also,
Okay.
we need to take some of the blame on that too, because even if a driver gets dispatched out there, it's so tough at egress to get into where we're asking them to go
Okay.
that
Sure.
if I was behind that wheel, I would blow that off too and go get something that's much easier.
Okay.
And that's something that we are actively working on to make sure that gets cleared. We do send Metro out 15 minutes before egress to get rid of all the double parkers that are on that street, to try to keep it flowing as much as we possibly can. But they get inundated with a whole bunch of stuff that's going on during that point, that it gets, it does get jammed up over there. So that's something we are actively working on as well.
Okay. Hey, thank you.
Thank you.
Just one question, Mr. Harvey. With regard to with regard to Sphere, you said incoming 500, exit 50. Do you have any comparable thought on Legion? Is it a drop-off problem or a pickup problem, or is it both?
So for drop-offs, and I think it's an awareness problem for the industry to not actually know where to drop off. And we do see drop-offs on Dean Martin quite a bit. And we do have 2 Metro Rovers that are going up and down Dean Martin, just ticketing rideshare, ticketing anybody that's dropping off there. I know taxicabs have gotten tickets for dropping off there. They try to tell them where to go, but spreading the word one driver at a time doesn't really do the trick. So we do see quite a few drop-offs over there. The problem is it's not so contained that we can actually keep a solid count of where they're coming to drop off. But that's something we can work on too, to get you some real numbers on what we're actually seeing over there.
Thank you. Yes, Administrator.
Thank you, Chair. I just wanted to let you know, it's brave of Mr. Garvey to show up here today and talk about these issues. A lot of these issues were created at the time that these plans were drawn up. I mean, Mr. Garvey and I had a conversation yesterday. We're going to get ahead of the curve when the A's come to town and that stadium is being built. Don't know if he will get the contract or not, but I know that if I had any parking issue around this country, I'd go to him because he's very good at it, and he understands the problem with the industry. And I believe that he's more than happy to work with us and try to get things going. When I had problems trying to get a taxi stand over at the Sphere, I called Mr. Garvey up and we had something as soon as the F1 race was over. We had to wait for that. But I just appreciate him coming today and kind of bearing his soul about this. And we will meet with the industry. We'll probably put a Teams meeting together after we get a little bit more information on what you're going to do, and we'll get everybody in the industry together and go over that plan. So
Sounds good.
Anything else?
no, that's all. Thank you.
Anything else from board members? When we get to agenda item 10E, future agenda items, we'll talk about. Okay. Thank you very much, Mr. Harvey. And not only are you brave, but you were very informational. Thank you. That concludes agenda item 4. Taking to agenda item 5, this is a regularly scheduled matter where the board opens up for industry discussion, allowing members of the regulated carriers to bring to our attention anything related to their operations that we should be aware of. Is there any member of the industry that wishes to address us at this time? I take it as everything is hunky-dory. I'll close agenda item 5. That takes us to agenda item 6. This is the time and place set for the public hearing on the application of the Taxicab Authority for a rehearing of the matter designated as CES and World of Concrete /Shop Show as a pilot special events and authorizing a surcharge. There are no interventions in this matter, and no oppositions were filed. Accordingly, my recommendation is that we grant the administrator's request for us to rehear this matter. Administrator, do you have anything that you would like to elaborate on this matter?
Just thank you for granting that if it passes. I believe that we need to consider the stakeholders in this situation. I think by continuing it, it'll give me an opportunity.
Well, we're not to the continuance, yes. We're just talking about whether we're going to give you a rehearing.
Okay.
So
All right. No.
you want your rehearing, correct?
Yes. Yes.
Anything else?
No.
I didn't mean to interrupt.
No.
Just
I thank you.
didn't want you to get out over your skis. That's the next thing. Member Weekly, do you have any questions or comments?
No, Mr. Chair, I'm fine. Thank you so much.
Member Graff?
Just to be put on the record, why you've asked for a rehearing.
Do you want me to do that now or wait until we're at item number 7?
Now's the time.
Now's, yeah.
Okay. The reason for the
You did file an application, so we do have that.
Correct.
application.
Yeah.
Yes. Yes. I've filed the application, and the reason is I need a little bit more time.
Okay.
I have no questions.
Okay, I'll entertain a motion.
I'll move to approve the application for the rehearing.
I'll second that motion.
Been moved and seconded. Is there any further discussion? All those in favor signify by saying aye.
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 None opposed. The application is granted. That takes us to agenda item 7. This matter is the public set for public hearing. In the event that agenda item 6 was approved, which it was, for us to conduct a rehearing of the decision designated CES and World of Concrete /Shop Show as a pilot special events authorization for surcharge, and during those events and at the locations of the Las Vegas Convention Authority and Venetian. On this matter, we have the following: Nevada Yellow, Checker Star Courts, New Cobb, and Taxi Management filed an intervention petition on January 31st, 2025. And the administrator filed a motion to continue the matter on February 11, 2025. My observation, just for the board's consideration, is with regard to the intervention petition. It does not comply with the requirements of the notice. The notice required that any intervention be accompanied by a memorandum of points and authorities on 2 issues. This intervention petition did not provide that memorandum of points and authorities. The board can either deny as defective or waive those requirements under the Nevada Administrative Code provisions, which allow us to deviate from practice if we wish. So I would suggest we first resolve before we go to the motion to continue the intervention petition. And I'd entertain a motion as to either grant or not.
Mr. Chairman, I would move to deny the intervention without prejudice. When I was chairing other organizations, sometimes I just wanted to get things moving along. When I first came to Taxicab Authority, I thought our procedure was so loose, it wasn't even procedure anymore. And I credit you with doing the extra work before the meetings to find out what the proper procedure would be and to straighten that out. And you've accomplished that. And I think we're better off for it. People know what to expect. They know they need to do it right, not just kind of ask for relief out there and not have a specific relief that fits statute or regulation. So with that, I would think we need to deny this intervention, allow them to refile it should they so please, and do it correctly.
And that's a motion.
That's a motion.
Is there a second?
and an
I'll
editor.
second.
I'll second the motion.
Been moved and seconded. Is there any discussion? Hearing none. All those in favor signify by saying aye.
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 None opposed. The intervention is denied without prejudice. Second item is the administrator's motion to continue the hearing. My recommendation or observations, I guess, are as follows. The rehearing was requested by the administrator and the agency. We've granted their request. They are asking for more time. Proceeding with a hearing, therefore, because it is the administrator's request, I think would be unproductive. I think there's two procedural options. First, you can grant the continuance to a time certain, or I believe you can refer this back to the administrator with instructions to request placement on a future agenda when he's prepared to proceed. My inclination is the latter, simply because it's his rehearing request. He's saying, I'm not ready to proceed today, wants more time. I don't know that we should set some artificial limitation on when he comes back to us. But you could either grant it for a time certain or refer for him to bring it back to us. So that's my preliminary observations. I'd entertain a motion.
Mr. Chairman, I do have a question of the administrator, but that is not going to impact how I feel about this. I would move that we grant the continuance.
I'll second it.
It's been moved and seconded. Discussion. You have a question of the administrator?
Just so I'm clear, as I don't spend as much time thinking about what goes on Paradise Road, is that CES is already over for 2025. When is World of Concrete?
I believe it's in June.
No,
They were both in January.
I'm sorry, yes.
So they're both over for 2025. So we're talking about this being effective for the 2026 events. It's only February. We have a lot of time. We do. We have a lot of time to get it right. Okay. That's what I wanted to know.
I have a question.
Yes, fire away.
It gets renoticed.
Yes, it would have to be, unless we set it for a time certain, it will have to be renoticed
And right now,
republished in the newspaper.
right now, the motion is to allow the administrator to place a future agenda item.
I don't remember our vice chair's motion, I believe, was to grant the continuance. He did not indicate whether to a time certain or for a referral back.
I would amend my motion to add the term continuance with a referral back from the administrator to make that clear.
Will you accept that?
I do, because that'll give, if the petitioners or anybody wants to intervene, they can intervene at that time.
Correct.
Okay. Yep.
Everybody understand the motion as amended?
Yes.
Motion is member Weekly, yes?
Yes.
Did you have a question? Oh, you're saying yes, you
No.
understand?
I said I
You
do understand
understand.
the motion.
So the motion is to grant the continuance, to refer back to the administrator with instructions to bring the matter forth. He's prepared to do so, including whatever notices are required. Do you understand that?
Yes,
Okay.
thank you.
All those in favor of the motion signify by saying aye.
Aye.
Those
Aye.
opposed? Thank you. That handles agenda item 7. Agenda item 8 is public hearing on the joint applications of Desert Cab and A-Cab Company to adjust Taxicab charges to include a pass-through software license charge. I will take appearances at this time.
Good morning, Mr. Chairman, members of the committee. My name is Pui Premseret. I'm an attorney with the law firm Brown and Premseret. It's a privilege to have my inaugural appearance before you today, as well as an honor to represent my client applicant, Desert Cab, and its principal, George Bell.
Any other appearances?
Chairman, my name is Neil Tomlinson. I'm here representing the patent holder, which is IBSC IP LLC.
Mr. Chairman, we do have quite a few individuals that are present that have traveled from afar. If I may announce their presence at the hearing for the record.
I'm going to just take legal appearances at this time. Are there other legal appearances?
Mr. Chairman, this is Josh Raskin speaking. Can you hear me?
I can.
Okay, thank you. I am from the law firm of Greenberg Traurig, and we represent Intervenor Curb Mobility.
Chairman Robert Uriel, Karen Farrell, attorney captain.
Can you, you get his name?
Robert Uriel, Y-O-R-I-O, Karen Farrell, counsel for captain.
Morning, my name is Rick Wade. I represent YCS Taxi Management, the related entities of Wade and Taylor Law.
Your Honor, this week you asked the legal counsel, James Yoon of Wilson Sonsini, Goodrich, Mazzati, also counsel for the tax.
For the
Patent holders.
Pat.
IVSC. IVSC.
In this matter, we have first a disclosure I am going to make under 233B 126 on the application in this matter was filed December 18, 2024. I believe supplemented on January 10th, 2021. On January 16, I had a meeting with a representative of Captain. At that meeting, they were not and are not a party in this matter. And the purpose of the meeting was to ask me questions about the procedure that is used on an application for a rate change and what timing would be considered, I would consider to be the likely processing time for such an application. And I was also informed that in this representative's opinion, there would be substantial questions of intellectual property law. It was suggested that they may be well beyond the capabilities of the Attorney General's office or the staff of the authority to have the expertise to process. My singular comments in that meeting were on that latter point. Many judges do not have intellectual property awareness and have to try cases, and that's what experts are for. I informed him that the applicants have the burden of proof. I explained to him as an example, the independent cab CPCN case where it would be within the board's discretion to refer this to a hearing officer, and that the issues of law would be, have to be litigated. I considered the conversation one of issues of law, not of issues of fact, and therefore it was my conclusion for two reasons that I was not limited from having that meeting on under 233B 126 for it was a procedural discussion. And I believed at that time, as I believe today, as the chair, and the other board members may have a totally different perspective, that the application is incomplete. And I am not sure there is a contested case at this point. I don't think, I think there was two reasons. One, there may not be a contested case at the time I had the meeting, and two, the discussions were within the parameters of 126. That's my disclosure. If I will indicate to the Attorney General's office that if in the processing of this matter, it should arise that I think that 126 does apply, I will consult with you before I would make any decision on a finding of fact or a conclusion of law.
Understood.
Any other preliminary matters by board members? We have an application, as I indicated, of December 18, 2024, a supplement of January 10, 2025, and an opposition to continuance February 18, 2025, filed by Desert Cab and ACAB. We have a intervention application and a motion to continue, the first on January 31st of 2025, the second on February 11th of 2025, by Nevada Yellow, Checker Car Corporation's New Cab and Taxi Management. We have a per mobility, we have an intervention petition of February 3rd, 2025, and an opposition to the application dated yesterday, February 18, 2025. And I understand board members may have not had adequate time to review that document. I will just characterize it for you. It appears to me to be in part motion to dismiss and part perhaps an answer. As to curb mobility, Mr. Raskin, it is my view, and perhaps as to Wilson Sensini also, that you're going to appear and represent a party in this matter, that you must comply with Supreme Court Rule 42 on pro hoc vice. The Nevada Supreme Court has, in my view, made very clear that unless an administrative agency has by regulation adopted a process that governs practice before it, the Supreme Court has retained jurisdiction over administrative appearances. So as to any attorney not licensed in the state of Nevada, you will need to comply with Rule 42 and associate local counsel. The Supreme Court has indicated to at least lower trial courts that if they believe there is a reasonable likelihood that the prospective pro hoc vice candidate would be granted the right to appear, which in the case of Greenberg Trug and Wilson Sensini, I have no doubt that they can commence the representation subject to timely completion of the requirements under 42, which require you to go to the state bar and then come back and get admitted by us as the tribunal. So that is a procedural matter I would bring to your attention and would expect you to comply with if you want to proceed in this matter. Before we hear from any of the parties, I'm going to summarize for you where I think this matter stands, which may help the parties in what they may want to say today. This is a rate-making application under NAC 706-471 and the related statute. I don't view, in my opinion, any of the pleadings as particularly enlightening, and I do not believe they are sufficient to show us what evidence would be necessary for us to consider the application in light of the statutory findings and the regulatory findings we would have to make in a rate making. I don't think there is any mystery, at least as to your current board, as to how rate making applications will be processed, because we processed last year a general rate case. And so there is example on the record of how we go about doing those. From what has been filed, there are some jurisdictional questions as to whether we can even proceed. And there are also issues as to whether the rate request is legally and factually justifiable under the statutory and regulatory findings and processes we have to occur, and whether it's in the public interest. Simply not enough information that has been presented to the board, in my view, for us to make any substantive decision today. Other board members may feel differently. In my view, this strikes me as much like the independent cab CPCN matter. I was not chairman at I was chairman for the proceedings, but I was not chairman at the time it was filed and processed. But I was chair by the time it was heard. That was a 9-day contested, 10-hour, 12-hour a day hearing with half a dozen lawyers, numerous witnesses, voluminous evidence, and that was after a hearing officer had the proceedings for 14 months. My view is that given at least what's in front of the board right now, it would be difficult for us to proceed today, but that will be a decision of the board. My thought is that pursuant to the administrative regulations for this agency, this matter could be referred to the administrator to appoint a hearing officer. Under NAC 706-894, that hearing officer can make recommendations and the administrator can resolve interventions pursuant to NAC 706-933. That hearing officer appointed by the administrator may also conduct pre-hearing conferences, determine what the evidence is that will be provided, can resolve procedural issues, can take initial arguments on motions, and can resolve those motions to the extent that they are not dispositive, and then bring to us a case that is in proper posture for a rate determination. The administrative regulations, NAC 706-963, also provide that the administrator and the hearing officer appointed by him can determine what briefs, points and authorities, and other information is required to process the case and order those to be prepared. And they can then either provide them to us directly or can summarize them and provide them to us at a later time. My view when I inherited the independent cab case was that the board had failed in one fundamental respect, and I do not think we should invite that to occur again. And that was that they let the hearing officer have no obligation through the administrator to keep us apprised of what was going on for 14 months. And accordingly, again, Vice Chair Soderberg was in that hearing with me, but there was a great deal of silliness that occurred for those 14 months that we then were brought to us not resolved. We spent a lot of time in ferreting out evidentiary objections. My view would be if we were to decide to refer this to the administrator, we should put some guardrails around such a lengthy period of time being expended to bring a case on. If the Public Utilities Commission can decide what the people of the state of Nevada are going to pay for electricity in 120 days, we should be able to do a rate case in that similar time period. But I think much of the procedural business could be handled for us. I will note for some of the attorneys who may not practice here, there is an appeal process. If you don't like what the hearing officer and the administrator does, you can come back and see us during that process. But it's my thought that that would be, well, that is my recommendation is to the board. Before I open it up for board discussion, though, I'll give the opportunity of the 5 lawyers to each have no more than 5 minutes to tell us what they think of the posture of the case right now. So.
I'm sorry, Your Honor.
No,
I'm
that's
sorry,
fine.
Mr. Chair.
I'm
Did you
not
say
his
five?
honor. I'm just a hack.
Did you say 5 minutes?
Yeah.
Okay, 5 minutes.
If you need more than 5 minutes, then we're in trouble.
5 minutes is perfect. Thank you, Chair.
Thank you, Mr. Chair, for your candid disclosure and your leniency in allowing counsel to participate prior to a formal Pro Hac BG application.
As each of you speak, will you put on the record because we have a less than wonderful recording system.
Hui Premsterd on behalf of the applicant Desert Cab and Principal George Balaban. Mr. Chairman, members of the committee, the reason we are here today is because unfortunately not everything is hunky-dory. Mr. Balaban, on behalf of the applicant Desert Cab, is one of the primary operators in town, boasting over 150,000 rides per month. A dispute has been longstanding among the patent holder IBSC, who purports to not only hold 4 issued patents, but has multiple patents pending. That dispute has been brought to the attention of Captain, who is a software as a service operator, has that system that my understanding has been utilized not only by the applicant, but industry-wide in some form or fashion. There has been considerable discussions and negotiations as to how to resolve the potential threat of exorbitant, costly patent litigation. And these negotiations have spawned over 4 years. Why we're here today is because my client does not wish to bear the potential 800-pound gorilla lawsuit to incur those costs that are commensurate with those types of suits, as well as to reach into his own pocketbook to have to fund that and potential damages. Of course, we're not here to state to the Taxicab Authority as to who is right or wrong, but instead to set the table as to what the formidable threat is. Present today, we have representatives from Captain. We have Andrew Myers, the CEO, JJ Bell. We also have their counsel here who has conducted his own independent evaluation of IBSC's patent portfolio. And on behalf of IBSC, we have Neil Tomlinson, as well as Mark James, and their patent counsel, James Yu, who can answer any questions that the authority may have with regard to that portfolio. And let me state that I do not profess to be a patent attorney. I don't have that skill set or background. However, I am in a position to assess the litigation threat. It is IBSC's position that its patents are enforceable, and that if enforced, not only will they seek a clawback of multiple years, but also prospective damages for potential patent infringement. In addition, these negotiations have taken place over 4 years, and this application is really the result of an arm's length business transaction compromise. In essence, I would almost analogize this akin to a motion for determination of good faith settlement, one that's brought before a court consistently, and where one assesses the fairness and the reasonableness of the settlement amount. And in that regard, you would look at the surcharge, which is the 50 cents per trip that's requested, and to parse that against what is the threat of damages. The average 6 to 9% that I'm informed are the damages that are assessed for patent infringement. In addition to that, the lack of uniformity that would come with that imposition because it's not a flat fee. Also, you would look at it under what is the impact on other potential patent infringers. By being uniform, none of the operators would have to dig into their pocket if it's a pass-through and fund litigation costs, which I understand is not always awarded to the prevailing party. So if litigation does erupt, the industry would be facing almost a zero-sum gain in having to fund $3.5 to $5 million per trial per patent litigation dispute. You would also look, is there collusion or bad faith? The parties are here before you as a full transparent measure. This is essentially a Hobson's choice. There's no one here that wants to impose a surcharge. There's no one here that wants to pay for litigation costs. And more importantly, you have to look at what is the extent of IVSC's potential quest for damages. And my understanding, or at least the business assessment, is the clawback of multiple years. And not to mention, you have lack of uniformity among the rates. And then once again, you have to look at what is the Taxicab Authority's goal is to really promote fairness and equity and stability to the consuming public in the transportation market. You know, as many mediations state, a good mediation is where everyone walks away and they feel like they have a bad deal. And this is precisely not necessarily a bad deal, but everyone's leaving something on the table. You have IVSC that's willing to walk away from what it believes is formidable damages. You have Captain that has spent considerable time and resources to address this issue. And then you have my client, who's the applicant, seeking to shield and insulate from further liability and protect his operations. And then lastly, you have customers who uniformly will have that surcharge, you know, in an economy that is already sensitive to price increases. So everyone is essentially leaving something on the table. We understand that the need to build the record, and we do want to make everyone available by reference of the representatives that are here from the various parties to answer any questions and to commence that record making should the authority deem necessary. So we would seek that the authority move to approve this surcharge, not through the analysis of a rate change, but more importantly, that this is a arm's length 4 years hard-fought compromise that we look at as essentially a Hobson's choice, but serves the mutual interests of all involved. Thank you.
Any other council wish to make a presentation?
Mr. Chair, members of the board, again, Neil Tomlinson on behalf of the patent holder, IVSC IP LLC. I think a little context as far as a little bit of a history of how these patents came to be, it would be helpful. This originally started with the freest transportation companies. I was outside general counsel for them for more than a decade. And they started a technology arm of the transportation companies. And it was called Freest Transportation Infrastructure. What they did was they created on their own, before any rideshare had it, they created an app called the Ride Genie, which was very similar to what you see today in Uber Lyft. And then they also had a regulator program called Ride Integrity, which allowed the regulators such as the TA and the NTA to be able to see the entire industry as it happened real time. There were extensive hearings before both agencies, the Transportation Authority and the Taxicab Authority, that approved a pilot program of these systems. Over the years, then the patent applications were filed, and eventually 5 patents were issued and 6 are still pending. So they have different years of issuance, and they would have different years of expiration. But this has been, this is not a Silicon Valley firm coming in trying to leverage an industry here. This is a local entity that came up with this entire concept. Did pilot programs here, were awarded contracts in other parts of the country to utilize their systems, and then later patented these systems. So really, with this application, though, it's much simpler than all that. I think the context is important, but the application itself is not expecting this board to rule on any patent issues. What they're expecting to rule on is whether the charge is fair and adequate and meets all of the requirements of the board. The riding public is absolutely getting a big benefit of all the systems that are now operating cabs. You may remember for many, many years, first off, it was all cash business for many, many years. Wouldn't even accept credit cards. They had the same hard state meter in there for almost 100 years, right? I mean, it was antiquated, and the legislature passed a few statutes that tried to kickstart a technology improvement in the industry, and that's where all this came from. So I just thought that background was helpful, and certainly the summary that the chair provided, I understand it. I think we all understand it, and appreciate that you giving us that summary.
Council?
Yes, sir, and thank you for the opportunity to speak. We'll do the pro hoc immediately. James Yoon of Wilson Sonsini on behalf of the patent holder, and Your Honor, I'm just gonna make a couple procedural points. The most important thing if we go forward with the fact finding, as Your Honor had indicated, is to make sure we understand what the scope and nature is. I've been a partner now at Wilson Sonsini 30 years. I actually teach the IP patent course at Santa Clara Law School. The one thing all patent lawyers agree on is that the litigation is expensive and it takes a long time. A typical patent litigation takes 2.5 to 3.5 years. It typically would run, and I think my colleague at Greenberg would also agree, it's not uncommon for it to cost $4 to $6 million of litigation. With regards to the patents that we're looking at here, there are 5 issued patents. These applications began in 2011 and 2012, as my colleague indicated, out of work that came out of here. It's a local business. And that the patent office has issued 5 patents, 6 more going. So the U.S. Patent Office and the trained examiners have looked at these for 13 years, considered hundreds and hundreds of references, and all the statutory requirements. The reality is that all litigation is uncertain. I've done 5 jury trials in the last 16 months. I can tell you that some go your way, some don't. They are uncertain. But statistically speaking, if it goes to trial, patent plaintiffs win 2 out of 3 times. That's the typical way of doing it. And the real issues here, and I think you want to hit 2 very important points. You know, I always tell people an IP asset is a little bit like, you know, milk in the midday sun, right? You have a certain time period in which you can enforce it. And there's been negotiations that have been going on for an extended period of time. And if there is not a date certain in the process, effectively that in and of itself would force litigation, right? And so I thought, for example, the comment about resolving it in 120 days or whatever the amount, I think certainty is important for a patent holder. If the process is indefinite and continues, given that situation, you may be forced in the alternative, not by a decision by anybody, but just time. So I do think that's the case. And the second one is that these things can be very expensive. So I am not someone who is familiar with the taxi authority or what you need for your statutes, but any guidance that we got from the administrator or anyone else as to the specifics that you would need to make your decision would be helpful. Because when it comes to patent law, the attorneys, the cases tend to be vigorously litigated. Both sides are likely to disagree. And in all likelihood, if you hired an independent third party, they would say there is risk here, substantial risk. They have defenses that they're going to run. No one knows what a jury's going to do. It'll be very difficult in any short period of time to get ultimate certainty. And I think that is what drove the idea of the settlement, is that 2 other points I would make out. I think it's clear from the petition is that if whatever the authority does it, it relieves everything from the past. Patents, you can go back 6 years in damages. The first patent in this case issued in May 19th, 2015. The more recent patents are from 2021 to 2024. The other thing is that in patent damages, once you win, you get interest for you should have paid back then. And then the parties are now on notice that IBSC believes it has patents that the industry is using. There are also defenses that were identified by the intervention. These can be aggressively litigated. And so my only other comment procedurally would be we'd want to know what facts were needed. And then I think the administrator should provide clear guidelines as to the boundaries of what would be permitted during the time period. Otherwise, it's one of those situations where the cure could be worse than the disease, where everyone would spend millions of dollars. And then ultimately, when the hearing comes, there would still be many open-ended questions. So any procedural guidance, any firm timelines would be incredibly helpful. That's all. I'm happy to answer any questions about any aspect of patent law or anything, and I'll keep it neutral. I'm sure that my colleague at Greenberg would agree at the points I'd be making. I know that we would disagree as to the outcome.
Question to the Patent Holders Council. Are you intending on filing an intervention so you can participate?
I would assume
Because,
so.
because I'm just going to be clear, the rules are you're either an intervener or you'll be a commentor.
Well,
I know you know well this, this game, sir.
Yeah, Mr. Chair, Neil Tomlinson, for the record, I guess I would say it would depend on what the direction of the board is here today. How we're going to go.
And I would defer to my colleague, he understands the procedure, I don't. But I would point out that it would be very difficult for to have any substantive hearing, especially about the specifics of the patents without getting the information from the patent holder in whatever the proper format they decide that would be.
Not lost on me, Council.
Yeah. Thank you. And unless any other questions?
Any other questions at this point? No. Okay. Any other council that wish to address us?
Yes, Mr. Chairman. This is Josh Raskin from Greenberg Traurig. First and foremost, I want to apologize for not being admitted prior to this. We will follow Rule 42 immediately following these proceedings. I will say that I do have local counsel, Elliot Anderson from our Las Vegas office, who is barred in Nevada. He is on the line here. And the purpose of having him here was to request permission to have me speak. So I thank you for letting me speak. So I'm just going to make 3 very quick points. First and foremost, Mr. Chairman, I agree with your initial inclination to think that this was not the proper venue to adjudicate these issues. The relief sought by the joint application rests entirely on a finding that the 5 patents owned by IVFC are infringed by technology included in the taxicabs. Despite the fact that some of the attorneys who have spoken today want the board to believe that the relief sought does not rest on issues of patent law. Throughout the joint application, there are statements that show that the true basis for their relief is the fact that the technology in these cabs infringes on these patents. And in fact, it goes beyond that. The relief rests on a finding that the technology must infringe those patents in view of the requirements of certain Nevada statutes. In addition to relying on a finding of infringement, it also relies on a finding that the patents are valid, because a patent that's not invalid cannot be infringed. And pursuant to 35 USC 1338A, that's a section of the patent statute, patent disputes like this one must be adjudicated in federal district court. The standard is that if the dispute raises a, quote, a substantial question of patent law, which this one certainly does, the federal courts have exclusive jurisdiction of the matter. And I can provide the board with a citation to a case if it would like. And so while I don't doubt this board's ability to decide complicated issues, the issues that the joint application asks this board to resolve relate to infringement and validity of these patents and is of the exclusive jurisdiction of the federal courts. So that's point number 1. Point number 2 is that we disagree with several of the premises for the requested relief. Number 1, we disagree that the technology provided by Curb infringes any of these patents. We've analyzed the patents, and in our opposition, we've included examples of why they're not infringed. Number 2, we disagree that the technology included in taxicabs must infringe these patents. We've analyzed the relevant statutes and do not believe that those statutes require that the technology disclosed and claimed in these patents must infringe. And we also disagree with the damages calculation. Damages in patent cases is a complicated matter to resolve. There are many factors that the courts consider. They're called the Georgia Pacific factors. There is almost always significant expert testimony around damages. And we do not believe that a conclusion that damages would be 3 to 9% or that the damages would be enhanced due to willful infringement cannot be, there's no credibility to that. And then lastly, even if this was the proper venue, and even if there was infringement of these patents by Captain, we do not believe that riders should be the one to foot the bill for the alleged private settlement reached between Captain and the patent owner. If Captain infringes these patents, Captain should be the one to pay for that infringement, or they should design their products so that they don't infringe. Curb has been able to do that. Curb has designed products that don't infringe. Curb has designed products that comply with the Nevada statutes. And Curb believes that it, as well as the rest of the industry, would be damaged if the riders were compelled to pay an increased fare just because Captain reached a private settlement with IVFC. That's all I have to say, and I'm happy to answer any questions.
Thank you. Council.
Thank you, members of the board, for allowing me to speak. I'm Rick Wade here on behalf of Yellow Checker, Star, New Cab, and Taxi Management. We filed a motion to continue these proceedings, and really the reason for that.
And an intervention.
And an intervention, yes. And essentially what the board is being asked to do is to decide the validity of patents, decide whether or not patents are being infringed without any information about those patents and how they're being used, whether they're actually having infringement involved. Now, we've heard over and over again today that there's been 4 years of negotiations to reach this settlement. That what those were is 4 years of closed door negotiations. YCS certainly didn't have any information about that. YCS didn't have any involvement in that. But YCS and all the customers in Las Vegas are being called upon to enforce that settlement by paying increased fees. And we've also heard a number of times today that litigation is expensive. We all know that. I mean, we've all dealt with litigation. But if you're looking at the amount of these fees, they are very high what's being requested, 50 cents a fare. And if you're looking at just Desert Cab, who was the one asking for this, they said they have 150,000 rides a month. Well, that would be about $75,000 in fees paid by consumers in a month, about $900,000 a year. And that's just Desert Cab. That's not everyone. So if you're talking about a fee increase, that fee increase to negotiate this settlement would end up probably being more than litigation would be over the course of several years. And we don't know how that litigation would turn out. We have to know, are these patents effective? Is the patented technology in use, and is it an infringing use? How long has it been in use? And can these patents be enforced retroactively? How far into the future can they be enforced? Some of these patents are several years old. We know patents have a time limit on them. They don't last forever. And once all that is done, then we need to negotiate a reasonable fee or go through litigation. Again, we don't feel that the fee amount that was negotiated behind closed doors between Desert Cab and IVSC is a reasonable amount. And so my client and the customers are potentially being forced into a licensing agreement that they had no input, they haven't seen, and without any opportunity to determine whether there's any legitimacy to the claims being brought, whether that technology is really in use. This is a massive fee increase being requested on the on-ramp system. And we agree with Curb that there are due process rights involved in this. I certainly believe that the members of this board are capable of making these kind of decisions, but we also recognize that we agree that federal court does have original jurisdiction over these issues, or exclusive jurisdiction, I should say. We just think they should be addressed on their merits, not on a private settlement that no one has seen. Now, with regard to Desert Cab's opposition this morning that was filed, it takes some leaps in the information that I want to briefly address. They attached some minutes from meetings 10 years ago that mention that the software existed. They have emails from a few months ago asking about information about the patents. But knowing that the software may have existed is not the same as knowing there was a patent. It's not the same as knowing there was a potentially infringing use. And it certainly is not the same as being a party to negotiating a settlement that we didn't even know the terms of. So our perspective is that YCS and the customers being railroaded into a third-party settlement we had no involvement with, based on patents and infringement that we're not even really aware of. So we're just asking that it be continued so that we can have a fair process.
Any other council wish to address this?
Thank you, Mr. Chairman. Robert Uriel, Car and Farrell, Council the Captain.
Are you admitted in Nevada?
I am not. Rule 42 will be
And some kind of a right to be in front of us too.
understood. But what I can speak to today are really 3 points. One is we've been litigate patent counsel to Captain for some time. I represented Captain in a patent infringement lawsuit brought in Nevada District Court by Curb. There was a single patent that was at issue in that case. Substantial litigation fees. The patent was invalidated, but Captain was not awarded attorney's fees. So it ended up with close to $1 million bill. Patent was invalidated. 2 of the operators in Las Vegas, including Bell Transportation, were added. There were indemnification responsibilities. So Captain had to take ownership of the case. More recently, I've been engaged by Captain to evaluate patents from IVSC over the years. Goes back a few years, and they had a single patent, and now they have 5 issued ones and 5 or 6 that are still pending. We were engaged last year to evaluate the portfolio. There are new patents that were issued last year to give an assessment of the strength and weaknesses of the patents, both on infringement and invalidity, various defenses that could be asserted. There are some of the points in terms of prior art that are referenced in the Curb Mobility submission. There is prior art. We've done prior art search to conduct that. And I would say, without getting into privileged communications, not all the patents in the portfolio are equal. Some are weaker than others. Some are stronger than others. When you assess the case, well, you do have to determine infringement and validity on a patent by patent, in fact, claim by claim basis. You have to look at the patent portfolio as a whole to determine whether a resolution outside of going to court is in the best interest of the client. We've done that work for Captain. I would say this with respect to jurisdiction. It is true, as counsel had mentioned, that if someone is seeking to enforce a patent, the exclusive jurisdiction is in the federal district courts. I don't understand that that's what this application is about. It's about whether a fair increase should be included as part fair based on facts and law, as the lawyers may submit to a resolution without going to a court to seek a determination of infringement, validity, and damages. So I don't think that there is that kind of prohibition on authorities' consideration of the approval the application.
Thank you.
And happy to answer any questions.
Any other council? Unless board members feel differently, I'm not going to take rebuttal. I think we hear all of the various positions. So is there anybody who wants to hear more from council about the case?
No.
You have questions of council?
Yeah.
But we don't need to hear more argument. Is
We
what
don't.
I'm. And
Nope.
and Member Weekly, do you need to hear more legal argument? Silence is golden. Go ahead, Mr. Graff, with your questions.
Is there a tolling agreement in place?
I do not believe so, but I am not certain about that. I've not heard that.
Does any council know?
I'm not aware of any total.
Mr. Chair, my speaker went out for a second here, but I'm okay. I'm listening very closely, and I appreciate the comments that I've heard so far, getting myself caught up to speed on this item. Thank you.
Okay. Great, thank you.
Is there an actual settlement agreement?
So, would you like to speak?
Again, Neil Tomlinson on behalf of the patent owner, IBSCIP. My understanding has been negotiated. There is no final signed agreement in place, but there's a principal term.
Is the settlement contingent upon this board making a finding and approving?
Absolutely.
Okay. Who are the parties to the settlement?
I'd have to let the patent lawyer describe how the licenses flow because I'm not a patent lawyer, but.
Big picture, A, B, C.
The end result of the agreement is that every fleet who wants to participate in this could, and that they would have a license, and any liability from the prior infringement would be waived. Any of the additional damages that are available would all be waived as part of that agreement. So it would include captain and every fleet owner who wanted to participate in this resolution. If they didn't want to, then we'll proceed with litigation against them. If they do want to participate, they can be resolved. There's resolved as to all fleets and to all, and the captain as part of that agreement.
Oh, I've got 1,000, but no, not right now.
Okay. Any questions, Vice Chair?
I don't have any questions. I have a comment, but it depends on where you're planning to move things.
Well, I don't make that decision. I just frame issues. I don't have any questions. I do have a couple of comments. So if you want to make your comments.
Okay. Well.
As preparatory to whatever we might want to do.
Well, first, I just want to say my head's spinning. I have not had to deal with patent law since you and I worked together in the 90s. I was very happy to leave that back in the 90s. But as I'm hearing more and more, and we've got some very bright people in front of us, almost unnecessarily, rate cases can be complex, they can be contested, but they're simple. I want to charge this rate. Here's my justification for those costs, and here's why it's in the public interest. Pretty much done. The statutes and the regs are very clear. We're hearing a lot of stuff today that has nothing to do with us making that decision, yes or no. And I haven't seen enough one way or the other. I can't tell you how I feel about it. What I'm hearing is, well, we're essentially de facto approving a settlement and patent law, and this happened and that happened. And God, I don't care. What's the rate? What's the justification? Is it in the public? It's in the public interest. Why? And if somebody doesn't want us to do that, Taxicab Authority, it's not in the public interest, and here's why. That's the case, and that could take 10 days or it could take 2 hours, but either way, that's the case. And so part of my feeling is to go back and file it right. The other part is refer it to a hearing officer with clearly 120 days or more, because there's a lot to weed through, but this isn't a patent case, and it's never going to be a patent case. It's a rate case before a regulatory board who regulates rates and practices. A little period on that. And anything else that's going to bring that into also their legal issues are just, it doesn't bear on our decision. And so, like I said, I'm kind of looking for a little direction from the rest of the board. Do we just throw this back and ask them to file it right based on the law? Or do we just move this over to a hearing officer and let them sort out the wheat, the wheat from the chaff, so to speak, and then when it comes back to us at a certain amount of time, we know we have a rate case and we can decide either to affirm their preliminary decision, or we can decide the actual rate case based on the metrics that we're supposed to approve rate cases.
A danger of having worked with somebody for too long is that you might have serious disagreements or commonality. I'm going to tell you, I agree with everything that the vice chair just said. This is a rate case. And he outlined for you the basic concepts. There is a cost of service. Is the cost of service established as a legal obligation? I have these drivers, I have this payroll. I have these cars, I have this maintenance. I have an electric system. Sometimes fires break out. I need you to give me some cushion as NV Energy when the fires break out for the possible cost of putting out fires and paying damages, even though you don't know what they are yet. So there's cost of service, and that's what our first job is. What is the cost of service? Council was saying, give us some guidance. Is the cost of service established? To McGrath's question, okay, well, where is the legal obligation to pay this as a cost of service? Just like there's a existing cost of service for using some IP that we have already seen in rate cases and approved. We hear the evidence on what the cost of service is. We determine whether it is properly documented and proven. And we determine whether the calculation of how the rate captures the cost of service is done mechanically correct in a way that it is a fair recovery to the certificate holder because they are in a privileged, they hold a privileged certificate and they're entitled to recover. And then we have to decide, as Vice Chair said, is it in the public interest? Is this a cost that should be borne by the public, or is it a cost that should be borne by the certificate holder? The leading example in Nevada that anybody who ever listened to a rate case is, you may think your CEO is worth $12 million a year. I do not. Public Utilities Commission tells people that all the time. I think they're only worth $6 million a year, and that's what you're going to recover. The rest, the stockholders can pay for. And so the other balancing test that we have to do is the public pays this part, the rate pay or the certificate holder pays this part. And those are the basic parameters. If I'm missing any, tell me, Vice Chair, but those are the basic parameters for a rate case. This is not rocket science. And while I appreciate the jurisdictional question, the question I have is there somebody purporting to tell us, and I don't want to know today, we would have to know, is somebody purporting to tell us that the federal court can enjoin us from conducting that kind of a rate case? I doubt very seriously they could do that under some IP theory, but that's just my uneducated lawyerly opinion of patent law from law school. So that's 45 years ago. So I see, I appreciate that you've all been in the trenches, and I get that, but I think we have a fairly easy process ahead of us. But you all need to make whatever kind of record you want to make, and you're entitled to that record, and ultimately a district court judge and the Nevada Supreme Court gets to decide whether we did the right thing or not in processing a rate case. And we have to do that due process because there are people who have made significant investments in their certificate and they're entitled to rate recovery. So we're going to be doing an annual rate review later this year. So those are kind of my reactions as well. I don't want to upstage any other comments you or Member Weekly have. So I'll listen to those and then I will reiterate what I think the path forward is.
Chairman Reeser would always upstage anything that I say. So justification, rate, public interest. That all breaks down into a bunch of different stuff. Three of the members are lawyers. So we're going to want to see contracts. We're going to see contracts at specific times. We're going to say, that may be your own problem. If you've got a contract that you signed, it may be your problem, not the public's. That's what I think we're all trying to say. I'm the blunt one, I guess. So that's what I'm trying to say is that's why I asked who the settlement was between. You can settle lots of cases. I settled 3 cases last week, but I only represented one of the people that had to pay money. So you have to figure out who's going to pay the money. And I think we've spent a lot of time on doing a similar rate adjustment last year and on surcharges and everything else. And we spent a lot of time, and we definitely keep the public's interest at heart. And we will always keep the public's interest at heart on these issues. Yeah, but there's a lot of information on terms of the justification that I think is going to have to be developed in a process that I think that Chairman Reeser was very wise, as always, in trying to give you kind of a roadmap at the beginning. So that's what I've got.
Member Weekly, any comments, thoughts, musings?
No, I concur with comments that were just made. I think the guidance that that I heard you give at the beginning before we started listening to the representatives here today, based on my knowledge of this particular case here, I'm just kind of getting myself caught up to speed and learning more about it. I can understand from the applicant in terms of it being really time certain from a fiduciary standpoint, but just there's still a lot of unanswered questions that probably still need to be addressed. And so I concur with your comments, Mr. Chairman. I think you're giving them some good guidance. Thank you.
So I will restate my thoughts on this. My thoughts are that we refer this to the administrator for the appointment of the hearing officer. That hearing officer conduct that you, and let me tell, I'm going to be very specific so that you can say so moved, okay? That the hearing officer reopen interventions and take interventions because some people may want to participate who have not filed petitions for interventions. That the hearing officer also resolve pro hoc vices under 42, which is part of the intervention process. The administrator can make those decisions on the record created by the hearing officer under NAC 706-894. We also refer to the administrator for a hearing officer to conduct one or more pre-hearing conferences pursuant to NAC 706-933, resolve any motion practice. There is essentially perhaps a motion to dismiss the application before us right now. Given what a rate case is, get the evidence assembled that would be necessary for us to determine cost of service and any public interest evidence that wants to be given, resolve any procedural issues, all short of making any dispositive decision about whether the application is granted or denied, because that is not within the administrator's authority. That authority is only in the board, and it is the only agency in the state of Nevada, other than a reviewing court, that can weigh in on that. Administrator, you understand that limitation?
I do.
Okay. And also refer to the administrator through a hearing officer to determine what briefs need to be filed for the benefit of the board in processing the evidence that is assembled. And I will tell you, my view is that you would have exchange of evidence, and we would be getting a binder of what the evidence is. And I would suggest to you the same suggestion I made in the independent cab case, that there be pre-filed written testimony so that we only have to do cross, just like is the practice in front of other rate-making agencies. And then report that back to us as you complete those tasks. You don't need to hold them all in one bucket. That starts appeal time for people if they want, if you deny an intervention and somebody wants to get in your face about that, then you can get that resolved before the horses are all out of the barn. I, like Vice Chair, try cases in front of the Public Utilities Commission. So I understand that this can be done unless people are trying to not allow it to happen within 120 to 150 days. So I do not see this as the fandango that I experienced in the CPCN application. And so sometimes I can be blunt. And I would want basically at each monthly meeting to get a report from the administrator. This is where I'm at on that 120 to 150 day clock. Because it's entirely plausible with the guidance that we tried to give today on what a rate case is and what it is not, that they could be back to us in a much shorter period of time. And I apologize in advance to Ms. Webb. Unless the board disagrees, I would entertain a motion.
So moved.
Are we going to give them deadlines on various things? Or are we going to allow the hearing officer to set the deadlines?
Within, but monthly reports.
Okay.
And our expectation is that they will have this done within 120 to 150 days and be back in front of us.
I'll second the motion.
I'm going to take, I can name that, to quote the chairman of the Gaming Control Board, I can name that tune in 1 minute for each council. Yeah.
Mr. Chairman, may we seek leave for 10 days to amend our application prior to the commencement of the process with the administrator?
Anything else?
No.
Council, anything else? 1 minute.
I think the 120 to 150 day time estimate seems reasonable, given my understanding of the issues.
Okay. Mr. Thomas.
I would just say that I think that I agree with what council just said about the 10 days, but I think it would save everybody a lot of time, because then you could reopen the PLTIs based on the amended application.
That's 120 days seems reasonable. I do echo Mr. Graff's point that as much specificity we can get in terms of when things need to occur, the better.
To your question,
Online,
yeah.
online.
Oh, yes, I'm sorry.
Josh or
Is Josh still there?
Yes, I'm
Thank
still
you.
here. I don't have any questions or anything to add.
sorry.
In response, so we've taken that, we're back to discussion on the motion in front of us. My interpretation of the answer to council's question is, because we are suggesting that interventions reopen, that we should probably build in a time for amendment to the application. And so she's named that tune at 10 days. Would you guys accept an amendment that the application can be amended in 10 days.
I would accept that for my
Yes.
motion.
Yep. And it's-
Member Weekly, you got that?
Yes, I do.
Okay, great. It's been moved and seconded. Is there any further discussion? Administrator, any questions, comments? I am inclined to say rebuttal, but no.
Lots of questions that I will figure out myself.
Okay. Well, you have Ms. Webb and you have DAG.
Yes, I do. Thank you.
So, do you have anything?
No.
Ms. Webb, anything unclear to you about your marching orders right now at this point?
No, but can I just say something?
As long as it's not, I resign.
No, it just, this will take you back to bar review. We went back to your,
Pardon?
this will take us back to bar review.
Oh.
I just want to make sure, because I hear all this going on, that the time frame that the TA needs and the TA board needs, in no way are the applicants a third-party beneficiary of our decision or how long we may need to make a decision. I know.
If I would restate your question
Please do.
to the board is a 100 or 150 day time frame binding on us and something anybody can rely on? Is
Well,
that,
because we don't know, it could take.
no,
longer.
but is that the question?
That is exactly.
Unless the Attorney General's office disagrees with me, the answer is no. This is a discretionary act. We can take as long as we think we need to process a rate case.
I just wanted that clear.
And the reason I state that for the Attorney General's benefit is the Nevada legislature has decided in rate making when it will require something to be done within a particular period of time. And it has never decided as to this body to place a statutory restriction, as it has done with other bodies, as to how long they will take to process a rate case. The example I gave earlier is if you're a PUC regulated utility, don't file a rate case unless you've got your stuff together because it's over in 120 days. And at the end of 120 days, it's yes or no. And other, not to get too far in the weeds, but when you determine what certain kinds of rates are allowed to pass through to gaming licensees for sports and wagering, those are set, there's time frames set on those rate determinations. So, but that does not apply to us. So my answer is no third-party beneficiary, and I think you would probably agree with that, Council.
Joseph Ostanian for the record, I'm fine with it, but if it does go over, do you want them to come back and request more time?
We're asking them to come to us every month with a report on how they're progressing on the 120 to 150.
No, I understand that, but if it goes over 150 days, do you
Well, I
want to?
think they'll be back in front of us each month, and we
Okay.
can say, hey, move it along. And we'll re-agendize this each time so we can take action.
And I'm comfortable with it, yeah.
Okay?
Thank you.
Any further discussion, questions? Okay, all those in favor of the motion signify by saying
Aye.
Dr. Weekly, are you and I?
Aye. Yes.
Okay, great.
Aye.
Passed. Thank you very much, Council.
Thank you.
Okay. The hour is 11:14 or so. Do we need a break? Are we good to?
I'm good.
We good to muscle through?
I'm good.
Okay. We thank and excuse Vice Chair Soderberg, who had told me that he had to leave at approximately this time and that I ought to have my shit together and get it done fast.
Okay. See you guys.
That takes us to agenda item 9. This is the public hearing on the joint applications of Blue Desert and Desert Cab by George Brad Balaban for authority to transfer non-voting membership units and non-voting shares in respective companies to legacy trusts and estate planning vehicles, and for BJ to transfer non-voting shares, voting shares, and non-voting membership interests to an asset protection and legacy council.
Good morning. For the record, I'm Kimberly Maxon Rushton with the law firm Cooper Levinson, appearing on behalf of the applicants, Mr. George Balaban and Mr. Brad Balaban. Sitting to my right is Mr. George Balaban. And also Chair Reeser, for the record, Mr. Burke Williamson from the law firm
Great.
Jeffrey Burr. He's our our estate and trust expert. So wanted him to be available too.
Good. And thank you, Mr. Williamson, for appearing. That was me who said to Ms. Rushton, maybe have a trust and estates lawyer here if she wasn't like going to tell us trust and estates 101. Thank you. Do you have any opening statement? We have, I will just make for the record, we have the applications. They've been on file for a while. We apologize that we couldn't take it in January. We didn't have a January meeting. You have provided us a volume of confidential documents, which we have accepted, and they are held confidential because they are private estate planning documents, but to edify us on what was going on, and we appreciate that. So I think the record is in proper form, and you may make whatever argument you want to.
Thank you, Chairman. On behalf of the applicant, I'll just summarize the applications before you. Specific to the statutory requirements, it is incumbent upon the applicants to present an application for your consideration requesting to transfer the interest in corporations that hold CPCNs. In this instance, as the record reflects, the CPCNs are specific to both Desert Cab and to Virgin Valley Cab. But more specifically, for estate planning purposes, both George and Brad seek to transfer non-voting shares to 3 legacy trusts that were specifically set up for the benefit of their children. As it applies to the asset protection trust, that is a conversion from the irrevocable trust that Mr. Brad Balaban previously had to an asset purchase. Most importantly, I think for the purposes of the record and for the board's consideration is the fact that the changes as proposed will not in any way modify the day-to-day operations and oversight of the 2 respective taxi companies. Also consistent with the specifics of the statute, and as you are familiar, Chair, with our work in front of the Gaming Control Board, the legacy trust specifically refer to the Taxicab Authority and confer jurisdiction there. Therefore, any modifications or amendments to that would have to come before the board for consideration and approval. As you indicated, we did submit the trusts as well as all of the accompanying assignments and assumptions, as well as the supporting documentation. I believe it is quite voluminous, but very succinct in the sense of what is important to the board's consideration. However, as noted, Mr. Williamson is present and he is a trust and estates attorney and is happy to answer any questions that you may have. Same with Mr. Balaban and myself.
Do you have anything you want to tell us other than please approve this? Please approve.
Actually, no.
Member Weekly, do you have any questions on this transfer application?
No, sir, I'm okay. I'm good.
And Graf. So, Mr. Williamson, it's been lost on me for 45 years. Can you tell me about the rule of perpetuities? No, I'm just kidding.
Doesn't apply to that.
I don't have any questions. The matter is well in order as usual, Ms. Rushton. And I would entertain a motion to approve.
I move to approve.
Member Weekly, you got to do this one.
I move to approve.
Oh, okay.
I'll second.
I got 2 motions to approve. I'll take one as a second. And any further discussion on agenda item 9? Hearing none, all those in favor signify by saying aye.
Aye.
You with us? Member Weekly, we need an aye or an A.
Was just there.
He might not know he's paid. Oh, there he goes.
We good?
Did you say aye or nay?
I said aye.
Okay, great. Okay, so pass. Thank you very much.
Thank you again.
Takes us to agenda item 10, which is staff reports. Administrator.
Thank you, Chairman. Without getting into detail, I would like to just bring the board up to speed a little bit on the financial status of the Taxicab Authority. A lot of reasons for revenues declining and issues that we are faced with financially. Having said that, I've got a statement from the Director of Business and Industry that he would like me to read in today because he is also in Carson City and unable to attend. So if you don't mind, I'll go ahead and read the statement. A statement from the Director of Business and Industry, Dr. Christopher Sanchez, Chair Reeser and members of the board. The department's analysis pertaining to the long-term viability of the Nevada Taxi Authority indicates that the agency will face a funding deficit by the end of fiscal year 2027. To address this, I have instructed Administrator Park to work with the board and the taxi industry to develop a series of options that might address declining revenue while the Nevada legislature is in session this year. I encourage the board to work with Administrator Park and industry stakeholders to develop a long-term solution. The agency's analysis shows that ridership has remained below pre-pandemic levels, but consistent since 2022. However, we anticipate that over time, ridership may decline. I look forward to working with Administrator Park and the board while we seek to address the 2027 deficit and the long-term viability of the industry and the Taxicab Authority. Thank you.
Any questions or comments on that statement from any board member?
What do they project the deficit to be in 2027? Are we talking $10 million or are we talking $10?
More than 10, less than 10 million. It's around 2 million.
Okay.
And I'm just going off of memory from projections.
Any other questions at this point?
What are the direct sources of revenue for the Taxicab Authority?
So we get 2 different fees from each ride. One of them is 20 cents. We call that the drop fee, which is the main revenue source that we have. And then there is also a technology fee of 5 cents from each ride. The drop fee has not been raised since 2003. The tech fee has not been raised, well, since it became a thing in 2013. We also collect fees from fines and medallions and applications and things like that. But those are the 2 main revenue sources for us.
Every ride, 25 cents.
Yes.
Okay. We do $1 million a month. That's $250,000, right?
Right.
So that's $3 million a year. So what's the total budget for Taxicab Authority?
Swag. Honestly, I don't know that answer off the top of my head, but I can get that for you. I deal in line items and have never really totaled up, goes out and comes in every year.
Okay.
Questions?
Not right now, no.
Member Weekly, do you have any questions on the statement we received from the director?
No questions from me. I'm okay.
So not a question, just a observation.
my observation of it. Yeah, and please forgive me for my delay. I'm pushing buttons when I mute and then my microphone. So anyway,
Okay.
just my observation. Yeah, I'm kind of still I'm in the middle of it all right now. I appreciate the what was just said by the administrator. Just I'm just kind of in the middle, Mr. Chairman. I'm kind of following you all's lead on this one here.
Thank you. So my thought, in December, we set the commencement of the annual rate review for March. I understand that we may not be able to complete that proceeding all in March. I would still leave it on the agenda for March and begin that process with a discussion of what governmental fee considerations need to be built into the rate review. I do understand that there's, lack of the ability of witnesses and experts may be a problem in March, maybe even longer than that because of legislative commitments. So, but I think I take Director Sanchez is saying, chop, chop, we need this by the end of the legislature. So I think in March, I would suggest that be agendized for us to consider and for you and your staff to take some swing at what we would have to do with our fee structure to address the shortfall, so that we would be in a position to send a recommendation to the director in March. And if he was going to say, you need to come to Carson City and testify or whatever, so we'd be in a position to do that. My other thought is, as you do that, I get the two recurring every ride sources, but there are other sources of fees, which I understand haven't been changed for decades and decades. Application fees, they're not set by statute. So you have some flexibility to come back to us and say, you want a driver's permit, it's not $1.385, it's something else. Yeah. So those are my thoughts. Any other thoughts from board members on that report item? Okay, great. Take it away, Administrator. Anything else you want to tell us?
I want to go over some numbers with you.
Okay.
Statistics wise. We did not have a meeting in January.
No, you had a meeting in January.
Yes, yes. But so I'm going to forego the December numbers and just
cut to the chase.
Yes, exactly. For the monthly trips, we had 1,087, or 1,087,195 for the month. The employee revenue was at $19.92 for this year, for the month. The lease revenue was at $20.26. The monthly combined trip comparison between 25 and 24, it's a little misleading because we don't have all of 25 yet, but around 1,087,000. Our medallions, to your point, have not changed. We're still at 3,530. The lease decals, 1,902. And then we'll get into the agency stats a little bit. Citations written in January were 85. In January of 24, we only had 32. The number of violations written were 91. And then there were 4 impounds in January of 25. I do want to bring up in December of 24, we had 9 impounds for that. The total violations resolved were 71. Again, our accidents are usually right around the same number. We had 230 in January. Last year, we had 270. I think it's usually right in that range of accidents every month. We had no assaults this month. That's good. That doesn't always happen. We had 24 complaints compared to 22 last year. And a lot of those come in by email complaints. And then those are assigned to our investigators and they go out and do an investigation. Found or damaged to the cab, there were 4 in January compared to 0 last year. Lost property, down a little bit. We only had 72. I say only, that's it's down from 90 from last year. And then targeted enforcement, we had 112 events compared to 104 from last year. 215 traffic stops, and I attribute some of that to we've had people in training, and so we're teaching and instructing and how the TA does those. So citations reports 91. The monthly vehicle inspectors 140. 160 for the 24-hour issued. Again, the accidents, I think 227, but some of those are bumper taps that they're not a part of that other accident statistic. We're still over 3,100 in cabs, 3,119 for January. So those numbers continue to go up, and I can attribute a lot of that to the police drivers. Disabled and elderly rides requested. I think there were 1,520 for the disabled and 686 for the elderly. And I do want to point out, speaking about that, I went out and met with Aging and Disability Services to talk about the TAP program. We are going to collaborate on trying to make that program a little bit better. I know Dr. Weekly has, we discussed that a little bit in the last meeting, and I have invited them to come to our next meeting to give a presentation on how they're handling that program. So I think that's all I have for stats.
Any questions on statistics?
It's just, no, I'm kidding. So on traffic stops, you said you were doing a lot of training last month, but just the difference between 117 and 215 from 2024 to 2025, is that the reason? Or?
I think so, Member Graff, because through our training program, we have regimented portions that we go out and do. And so instead of going out and enforcing everything when you're not training, during your training times, you're specifically looking at certain aspects of the job. And I think because we have been training, that's a big reason for it. But I also think that we're doing more targeted enforcement as well. And recently I purchased a LiDAR gun, which is a speed detector gun. And I think the enforcement guys are going out and using that more often.
Okay. All right. That's all I have.
Dr. Weekly, did you have any questions on statistics?
No questions. No, thank you.
Ms. Webb, anything we need to know?
I just want to let you know that there will be, after the next board meeting in March, a workshop regarding changes, potential changes to the NAC.
So as I understand, it was, did I interrupt or?
No, I'm done.
Okay, so as I understand, you will, the administrator is going to be bringing to us proposed regulations, which we have to workshop under 233B. So we will need to add to our agenda. You know, we finish our regular agenda and then we'll go into a workshop agenda, which we are required to do to let them advance the regulations to LCD. Okay, and we'll take evidence from you and evidence from the public at that time.
Chairman, you also had mentioned the March meeting. I thought we were going to try to continue that rate, the rate.
So on the rate review, we determined in December should be done in March. There was an action item taken. That's my recollection from the minutes. So my thought is, even if the industry is not prepared to present their request for any rate relief in March, we should nevertheless commence the proceedings and first start with a review of, as I stated earlier, what needs to be done relative to the budget of the authority. Could be wrong, but that might influence what analysis is done by the certificate holders, because they got to bake that new cost into their rate structure. Their cost of service will be their cost of service, but Ms. Rushton can come up and whack me around if she wants. I'm not saying you need to. I never invite to be whacked around, but regulated entities also make decisions not to ask for a rate increase on the whole if they think it's going to be, there's going to be a loss of ridership, for instance, because it goes too high. They may. So I don't want to prejudge what the industry might do, but I think it's fair to the industry to hear up front what we're thinking about tacking on to the meter, if anything. But given the length of time since there's been a change, granted CPI increases to the industry, but we didn't do any CPI increases to ourselves. So I see an issue there that we'll have to struggle with. So I think they can tell us in March, this is what time they need to present theirs, and we can continue that hearing from that time period, but we will have at least noticed it so we can start the rate review process. I feel fairly strongly that we need to get back on this annual obligation. It's a statutory obligation. We hadn't done it for a long time. We said, let's do a general rate case, true up everything, and then after that, we'll attend to this. But I think in fairness to the industry in presenting that information, they probably need to know what our thoughts are about what we're going to tack on to the rate. Now, Ms. Rushton, if you have anything you feel the need to correct me on, okay. Was that what you were thinking about?
It was exactly, thank you.
Okay. And then before I move to other future agenda items, did you have anything we needed to consider? Okay. The other item for future agendas is the discussion that we had beginning the meeting on parking issues. I understand there'll be some back and forth and dialogue on that, but I would ask that at some appropriate time, in the not too distant future, before for the football complaint season begins about surface transportation, we have some feel for, do we have a solution here, or are we going to need to gear up for dispatchers to get all those complaints about no cab showing up? So bringing back the parking matter would be helpful.
Yes.
I didn't have any other future agenda items. You? McGrath?
No, maybe the chance of getting the new parking vendor at Sphere to come in and talk to us. It's good to look back, but it's always better to look forward.
I have invited Alon, his Kodiak, I believe. I've invited him to a meeting. He is not opposed to it. We just have not firmed that up yet.
Okay.
Member Weekly, is there anything you would like on a future agenda at this point?
Not offhand, Mr. Chairman. I'm okay right now.
Okay, great. Enough is enough, right? Okay, then I will close agenda item 10. That takes us to agenda item 11, our second public comment session. This matter is on our agenda pursuant to the Nevada Open Meeting Law. It is a time for members of the public who wish to address us on matters within our jurisdiction to do so. We can't take action on those items, but we certainly welcome any public comment. Is there any member of the public present in the hearing room in Las Vegas who would wish to address us? Seeing none, is there anybody participating remotely who wishes to address us? Thank you. Hearing none, I will close our second public comment. I'll entertain a motion to adjourn.
So moved.
On this purely procedural matter, I will second. All those in favor signify by saying aye.
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 Member Weekly?
Aye.
Yeah, great. We are adjourned.
Are we meeting?